right is still right, even if you stand by yourself.
Chief Justice, may it please the court.
Welcome to Case in Point, the legal show for regular people. I am your host, Sarah Parshall Perry, a senior legal fellow here at the Heritage Foundation in Washington, D.C. I am a regular lawyer, but cooler than most. I am indeed, actually, as we record this, wearing fringe suede boots that are knee-high. Tell me how many lawyers you know would wear that. It's just me. That's why I'm the best possible host for a legal show for regular people. Today, we have a huge guest with us. Attorney General Jonathan Skrmetti, who is coming from the great state of Tennessee, simply a day or two after the oral arguments in United States versus Skrmetti, a huge case at the Supreme Court, the biggest of the term, that held oral arguments this year on whether or not his state can constitutionally pass a ban on so-called gender-affirming care for minors. We're going to hear his thoughts on oral arguments. We're going to find out from him where he thinks the strengths and weaknesses are in his opponents, the United States' position are, what he took from the justices' lines of questioning, what stood out to him, and what his plans are next as the Attorney General for the great volunteer state, Tennessee. So that's this edition, a special edition of Case in Point. I am so excited to be joined today by Attorney General Jonathan Skrmetti of the great state of Tennessee. And we're going to talk about some really impacting litigation at the Supreme Court. The Supreme Court heard oral arguments yesterday in what could be, and I believe is, the biggest case of this particular Supreme Court term. I'm very excited to talk with him today. I want to tell you a little bit about his background before we launch into some questions. He clerked on the Eighth Circuit Court of Appeals. He's been a federal prosecutor. He's taught cyber law. He has been at Department of Justice, and now he is the Attorney General of the great state of Tennessee, the volunteer state. Welcome, Attorney General.
Thank you for having me.
All right, so let's jump right into it. We know the Supreme Court heard oral arguments yesterday in United States versus Skrmetti, and I was there, and you were there. You were in the courtroom. I spoke outside, and the crowds were spectacularly raucous, I would say. I was there early, so I didn't catch sort of the burgeoning sort of kerfuffle going back and forth between both sides. But this is an issue. This case concerns an issue that really elicits passions on both sides, right? It's a really hot button issue. But at bottom, to my mind, and I think to yours, it's a very simple constitutional cut and dry question. But I want to talk, first of all, about what's at issue. And the law being challenged is Tennessee's SB 1. So tell me about that law.
So SB 1 is a law passed. It was the first law in both the House and the Senate introduced last legislative session. And it prohibits the use of puberty blockers, hormone treatments, and surgery for minors for the purpose of gender transition.
Okay. And what surprised me when I was researching this case and writing on this case was that SB 1 was actually enacted with bipartisan support. That surprises me.
It was only a little bipartisan, but these days you take the bipartisanship you can get.
Yeah.
And this is not your typical culture war issue. If you look at the coalition of people aligned against juvenile transitions, it includes your traditional conservative groups, but there are also these LGB groups that are very concerned that transitions are being used essentially to eliminate gay youth. They've got very elaborately articulated concerns about that. And there are medical groups that aren't particularly political, but are committed to their craft, their profession, and are deeply concerned at the lack of evidentiary basis for these life-altering treatments. So it's a bigger group of people worried about this than if it were just simply an ideological fight.
Yeah, and it actually, I think, makes it easier to advance the arguments of common sense and rational thought to say this is not partisan. It should be absolutely value neutral. We all want to protect kids, right? And so I think what we're fighting against for a lot of this is rhetoric. And I want to get to that in a second, but I want to talk about First of all, what happened yesterday in oral arguments? Specifically, the posture here is with the United States having sued you are the named respondent, over your authority to enforce the law, but it actually originated with 3 parents and a doctor, parents of transgender minors who were seeking access to these medications and hormones for their minor children. Now, they also had advanced the same claim as the United States, which is a violation of the Equal Protection Clause of the 14th Amendment. But I want to talk a little bit first about the parental rights claim, because that did not come up. It's not part of the consideration in the United States' case. But I want to talk about that parental right, because what we've heard is that, listen, there's a parental right. The Supreme Court's recognized it for 100 years. That includes getting medication for your child. How do you answer an individual who says, I have a right as a parent to get this for my child?
Well, first of all, I mean, I don't question that these are parents who are trying to do right by their kids. I think we have to be sensitive to that. These are kids who do have a very difficult time, and their parents are trying to help them. And, as contentious as this gets, I don't think we can lose sight of that. But with respect to parental rights, the state has a role to play. Parents should be making most of the decisions for their kids, but there are limits on that.
Yeah.
To use a non-medical example, if you're over 18, you're allowed to make pornography.
Yeah.
But if you are under 18, your parents can't say that's okay, because we recognize there are profound consequences for kids in situations where adults can make a knowing decision, and whatever happens, at least they're in a position to consent. Kids can't consent. And so there are limits to parental consent for children. And here we're talking about, and this will get a little into the substance of it, but we're talking about a procedure where the evidence in every systematic review shows minimal to no benefit for kids, where the risks are enormous.
Yeah.
Puberty blockers are not just a pause button. There are lifelong conditions that can result from being on those for an extended period of time. Hormone treatments can have profound impacts on a developing body. Fertility loss forever. Loss of any sort of sexual function forever. Blood clots, tumors, cognitive impairment.
Yeah.
All these really significant conditions. So you're getting essentially no benefit. You've got all this downside risk. That's a situation where the state can step in and say, we don't think kids should be subjected to this. That is imposing consequences on them outside the scope of what can reasonably be imposed. And of course, in the gender identity context, the research, especially the research prior to everything becoming hyper-politicized, showed that the large majority of kids who had gender identity issues would outgrow them.
Yeah.
That the best cure for most of these kids was time, unless they were put on medications. And given the just life-altering impact of these drugs, it is very defensible to say that children should not be subjected to this.
Yeah, I think so too. So the United States intervened, and what was their claim? Why did they claim that this was unconstitutional, and what were sort of the parameters of their argument?
So they claim that this is a violation of the 14th Amendment Equal Protection Clause, and You'll forgive me. I'm not 100% in the briefs, but I'm pretty sure the 2 arguments that they raised there, I think there were only 2, were that this is sex discrimination because you are treating girls differently than boys, and this is violating the rights of transgender Americans who are entitled to constitutional protection as a result of their transgender status.
Yeah.
Which is, Bostock is a case that looked at the sex discrimination argument in a very specific statutory context. And so the sex discrimination argument essentially takes the Bostock argument, which is the only real gender identity case that the court's ever decided, and tries to import that into the Constitution. And then the transgender status argument is I think it's fair to call it a long shot. It's been many, many years since the Supreme Court recognized a new suspect class.
Yeah. So 2 things I want to talk about, because you brought up 2 really good points, and those were very clear in oral arguments. But to clarify for our listeners, first of all, we talk about Bostock, and this was sort of blowing up yesterday on X, because you're right. It is the only gender identity Supreme Court case we have. Bostock versus Clayton County, 2020. Justice Gorsuch writes the majority opinion saying that under employment law, Title VII of the Civil Rights Act, sex discrimination includes gender identity discrimination because the 2 are inextricably linked. So did not surprise me to actually see Bostock make an appearance in oral arguments, and we'll get to those in a second. I would agree with you that there's a completely different analysis here, right? So the constitutional question and the statutory question both address sex, but the reasoning for the court and the calculus through which they have to approach this issue is completely different under constitutional law than statutory law. So I did see that come up as well. And we're going to talk about suspect classes. That is for purposes of equal protection clause analysis. We've always taken a look at someone's immutable characteristics. That has been, for as long as they've issued jurisprudence on equal protection law, the bright line in equal protection jurisprudence. And in fact, they've turned down other opportunities to include different areas such as disability or poverty. And so what the alternative argument was, in my reading of the briefs, was that the United States wanted to argue, all right, first it's sex discrimination, but if you don't buy sex discrimination, then it's transgender status discrimination, and that should be seen as a new suspect class. Except that Justice Alito, I think, had a brilliant line of questioning with Chase Strangio, the attorney for the ACLU. And we'll get to that in a second. So it's sex discrimination. And if that doesn't work, it's transgender status discrimination. And it's unconstitutional no matter how you cut it. What was their primary argument about why this law discriminates based on sex? Because I thought it was a real stretch.
So the argument is essentially, if you have boys and you have girls, and Tennessee's law prohibits boys from getting testosterone for gender reassignment purposes, or gender, the terminology is a little tricky.
We're using air quotes with affirming care.
If you're giving boys, if you're giving boys estrogen to transition, if you're giving girls testosterone to transition, and you're prohibiting that, then boys can still get testosterone for other purposes. Girls can still get estrogen for other purposes. And therefore, you're treating boys and girls differently, and it's sex discrimination. Now, we think we have a pretty good response to that, which is you don't just give people drugs. When you're talking about treating medical conditions, the drugs that you give them are given for a specific purpose, and the context matters. Giving somebody morphine, this is the example my Solicitor General used, giving somebody morphine to treat pain is very different than giving somebody morphine for physician-assisted suicide.
Right.
Or, for the lower class people among us, this is the example I use. If you cut off somebody's leg because they have gangrene, that's very different than cutting off their leg because they stubbed their toe.
That's exactly it.
And in this situation, when you give a boy testosterone because he does not have sufficient levels of testosterone, you are curing potential medical problems. You're ensuring that his fertility develops normally. You are ensuring that other conditions that come from testosterone deficiencies in boys do not emerge. When a girl gets testosterone to treat the psychological condition of gender dysphoria, you're actually creating new medical conditions. You're creating
almost sort of overly medicalized.
Yes,
you're creating patients for life.
Yeah, and you're going to cause all sorts of issues, including blood pressure issues.
Yeah. Liver cancer, I've read, which shocked me. Yeah.
Serious medical complications, in addition to a very serious risk of losing fertility forever. of losing the ability to enjoy sexual intimacy forever.
Yeah.
These are very serious downsides. So in one case, you're treating disease. In other cases, you're creating disease.
Yeah. It seemed very cut and dry to me. And I think Matthew Rice did a great job with this.
He really did.
That this is simply a restriction based on age and the purpose to which the medications are put. Just because they have different effects on different parties, whether you're male or female, because boys and girls, and Clarence Thomas pointed this out, there are different physiological impacts in estrogen with a girl as there are estrogen with a boy. Just because the effects are different doesn't mean it's a sex-based classification and unconstitutional.
And at the end of the day, the key factor here is that boys and girls are different. They just are. Every human being is a boy or a girl, and medicine will affect them. Some medicines will affect them differently because of that just foundational biological reality.
Yeah.
There's nothing discriminatory about recognizing that there are differences. Ruth Bader Ginsburg, the great feminist of the Supreme Court, recognized enduring physical differences between men and women. And to say that Tennessee cannot regulate these treatments to kids because boys and girls are different seems to me to be driving us down a path of absolute legal absurdity.
Yeah, I would agree with that. All right, so let's do a 30,000-foot perspective about oral arguments, because I listen to a lot of oral arguments. I know that you do too. They went long, 2.5 hours, which I think surprised some of us because it was the only case on the docket to be heard that day. You walked out of the courtroom and at a press conference, you declared victory. Tell me why you thought you were victorious.
Well, I hope I didn't actually declare victory. I mean, I think the arguments went well for us. We got our case out. The court was paying close attention and went long because they had a lot of issues to cover. I don't want to prognosticate. There are months until the opinions come out.
Yep.
And there's a lot of time for deliberation. I don't know what the justices are going to do. They are going to be thinking very hard. I think it's fair to say very hard about this case because of the potential precedential effect. So the victory is in putting on a good case for Tennessee.
Yeah.
I'm definitely not spiking the football on the outcome, but I think it did go well. Matt Rice is phenomenal. He had a great argument. He was pressed very hard on some pretty foundational questions, and he held his ground, and I thought did a terrific job of responding. There were some important concessions from the other side. So I left, feeling like we have done everything we could do to put Tennessee in the best position to win this case that we could.
Yeah, I would agree with that. Having listened to it thoroughly and writing on it sort of with my present sense impressions, there's a legal term for you, from my old trial days, I will say that it seemed, just based on listening, that if you had to make a judgment today, at least for me, and I will prognosticate, even though John Malcolm hates it when I do this, I will say I feel as though, based on their lines of questioning and their interaction, 5 of the justices seem very keen to uphold the law. There was something that was interesting to me. Justice Gorsuch was stone silent the entire time. What are your guesses as to why that was?
I mean, I think he was thinking really hard about these issues. Bostock is the only guidance out there right now, and the lower courts have been trying to figure out what it means outside the narrow context in which it decided. I don't know that he was doing anything other than listening very carefully and thinking really hard about exactly what the law is going to look like going forward, because the dearth of precedent in this area and the fact that so many cases have come up so quickly means that whatever the court says here, even if it's a fairly narrow opinion, will be read by the lower courts, at least until more guidance comes along, very aggressively.
Yeah.
And so, Justice Thomas famously didn't ask questions for a long time.
Yeah.
Didn't mean he was not an exceptionally productive justice. So I don't think you can read too much into that. It would be nice to get more clarity from the justices in oral argument, but that's just not the way it goes.
I think the two justices that stood out to me in terms of their level of pressing of both Chase Strangio, the attorney for the ACLU, and U.S. Solicitor General Elizabeth Prelogger. Certainly Alito. Alito was ready to throw down, I think, a couple of different times. The Chief Justice surprised me in the sort of strenuousness of his really urging sort of a cautionary approach. Even Brett Kavanaugh, who himself mentioned the yellow light, if not very strong red light, indicated by European nations who were fast-tracking medical transitioning of kids, suddenly backing off. That, I think, really stood out as kind of a seminal moment to me. What to your mind, were one of those one or two interactions that were sort of notable above the rest?
So the single most important part of the argument from my perspective was when Justice Alito pressed Chase Strangio on the rate of suicide.
Yes.
Because for years we heard you can either have a live son or a dead daughter.
Yeah.
And there was a lot of pressure on parents essentially threatening them that your child will be dead if you do not allow them to undergo these very serious life-altering treatment courses. And the research doesn't bear that out. But of course, suicide is in part a social contagion issue. And so the more kids hear the message that you're expected to kill yourself if you're not allowed to do this, the greater the risk that a kid is going to do that.
Yeah.
So bringing clarity to that is, I think it's going to save lives. I think the fact that they had that colloquy separate from anything to do with the outcome of the case is a huge win for kids who have a lot more, I think, hope now.
Yeah.
The other thing that stood out was repeated references to the importance of the democratic process. And of course,
Yes.
This is America. We live in a constitutional republic. We live in a representative democracy. And the people, through their elected representatives, are supposed to make these choices, except where the people, through the Constitution that they adopted, limits the power of the government.
Yeah.
So here, where the Constitution is, we think, silent, the people's voice should be the determining voice. And it was heartening to hear that from the bench. I think for the good of America, a strong dose of judicial humility will essentially force us to learn how to govern ourselves again.
I think that's beautifully put. That was, in many respects, and I said this, I would say probably a year or so ago when Skrmetti first came to the court, that they could avoid some of the trickier constitutional questions with regard to suspect classes and heightened scrutiny, and whether or not they were going to recognize gender identity as sort of deserving of extra levels of protection like we've treated with sex and race and national origin, and literally look simply 2 years back at the Dobbs decision. And Dobbs actually did make a brief appearance yesterday in oral arguments, as did Bostock, which is heartening for somebody who writes on this stuff so much, just to kind of hear the things that I have actually heard about and thought about come up and think, oh, I wasn't so off the mark on this. That issue, that highly charged, controversial medical issue, was sent back to the people and their elected representatives. And almost verbatim, this stood out to me, the Chief Justice, without attribution to Dobbs, used that exact language and said, why is this not a better issue for the people and their elected representatives? And so my ears perked up because I thought, at bottom, this wouldn't just be a great opinion to uphold the Tennessee law to protect children who are so vulnerable, but it would also be a win, I think, for representative democracy. And I think that's part of the opportunity here that the justices have to get it right. I thought that was a really compelling dialogue. So your reference to that, I think, is spot on. Powers not explicitly laid out in the Constitution are those for the people under the 10th Amendment, that plenary police power we hear so much about. And we know the Supreme Court has said, medicines included, states restrict the use of drugs for certain purposes or procedures for certain types of ages. Some states, for example, have parental notification laws for abortion. Others don't. That is sort of the mottled and sometimes messy nature of a constitutional republic. When you give the power back to the people, they elect those individuals to represent them at the issue, at the level to which they are closest to be governed. What did you think about, and this is, I think, got a fair amount of airtime as well, about Justice Jackson's reference to Loving versus Virginia? And that was the case in which the Supreme Court invalidated a state law passed by a Democratic body that invalidated interracial marriage. And in that case, they found it was a violation of the Equal Protection Clause, which is something that the government is arguing here. What did you think about that analogy? She was kind of trying to, I think, draw in characteristics and how that's not something that we want to focus on. But what was your take on that?
So, I mean, I thought that's what she was doing. Now, she has received a lot of criticism online.
Yeah.
And I think a good bit of it is unfair. I mean, our position is very much that her analogy does not apply in this situation, but she was trying to point to precedent, which is something the court does all the time, and say, if we have a case that says if you have multiple categories of people and person in this category can do something, a white man can marry a white woman, but a person in this category can't, a black man cannot marry a white woman, well, that's discrimination under our reading of the Equal Protection Clause. Here, if you have a boy who could take testosterone but a girl who can't take testosterone, how is that not the same? Now, we've already discussed it's because medical treatment is based not just on the identity of the person receiving the treatment, but also the condition to be treated.
Right.
And so there's a substantial difference between saying in this legal construct of marriage where the underlying fact is people are people, that you're going to use race to discriminate. That's different than saying boys and girls are different and drugs will affect them differently. That's just biological reality.
Right.
So I think that her emphasis on that, I think our reading is better, and I thought the Solicitor General ably answered her questions on that front. But I think that it was a line of questioning that we expected, and it's in line with what the government was arguing. I don't think it was unreasonable. I just think it's wrong.
Yeah, I do too. And I think her reference to characteristics, that harkened a little bit back to Bostock, because Gorsuch relied on, okay, you have a male who dresses like a female and a female who dresses like a female, and one you retain and the other one you fire because you're not tolerating traits that are not expected or characteristics not expected in that particular sex. That's sex discrimination. I heard a little bit of that in her line of questioning to say, okay, so if you're talking about characteristics and you invalidate because of a race discrimination categorization in Loving, then we should also invalidate based on a sex consideration here because you're tolerating characteristics in a girl that you're not tolerating in a boy. And I think, again, the easy answer to that is, and I think, again, that Mr. Rice did a fabulous job responding to this, that there is a very easy answer, which is, wait a minute, the medication has different impacts on both sexes. That doesn't make it a sex-based classification, right? Just because a woman can get an abortion and a man cannot get an abortion, or a woman can get pregnant, a man cannot get pregnant, and she gets pregnancy benefits or she gets her abortion paid for, doesn't make it discriminatory. That's a function of basic biology. And that the Supreme Court has held as much in other cases relative to specifically abortion and pregnancy.
We all learned how to say geduldig.
Yes, we again, all of the civil rights greats came out to play
Skrmetti, geduldig, we're inflicting really difficult names on the world.
Yes, all the civil rights greats came out to play yesterday. But as somebody who's been a civil rights lawyer for a long time, it was fascinating to me to see sort of that we're at the apex of this moment where we've divided ourselves into smaller and smaller and smaller classes of individuals. And now all of a sudden, we've created a problem for which there's this Gordian knot that we can't untie, because that's really what the transgender identity is. I think that's a function of where we've gone culturally. What's your take on that?
No, I think that's right. I think the issue here is gender identity is fundamentally different in terms of classifying people than the previous classes that have been prominent in civil rights litigation. And the existing precedents aren't conceptually designed to handle it well, because you essentially have two layers. You've got to have the biological sex, and you layer the identity on top of it. And that two-step identity is not what the prior cases have been looking at. So it is this tangled situation, which is one of the reasons I think it was such a long argument. The court is trying to figure out what language to use. It's trying to figure out what boxes to put things in, or it may be that we need to create new boxes doctrinally to address the arguments that are being raised here. So this really is sort of stressing the existing structure of civil rights law just through the nature of the asserted identity. And to be clear, like, gender dysphoria is a real thing. It is a difficult thing. I hear we're trying to commit genocide against transgender people through this litigation. That's not the case. Like, the issues being addressed here are that the research uniformly shows, when you do a systematic analysis, that there's not much of a benefit for kids from this. That kids are being subjected to big risk for no benefit. And we're allowed to protect kids. The Constitution allows states to do that. It doesn't mean that there aren't people with gender dysphoria. Now, another issue is the number of people being treated has skyrocketed. The number of kids claiming diverse gender identities has skyrocketed. And that seems to me to be substantially different from the gender dysphoria that has been identified over time. So there's, in France, there are concerns that there's a social contagion element here. The research has shown clustering in the data. I know that's a very contentious topic to talk about, but the explosion of numbers has created a real basis for concern. The radical treatments that have become distributed much more liberally than they were in the past. I mean, I don't know what the history of treating kids with these is, but the number of kids who are being subjected to this irreversible treatment. I mean, if they're on these drugs for a substantial amount of time, there are going to be effects for the rest of their lives. And more significantly, once they go on this course of treatment, it seems like the progression to the next stage is almost inevitable. So it's not just taking puberty blockers, it's being put on a path toward permanent changes to their bodies that will deprive them of some really significant functions. So I understand the emotional sensitivity here. This is not a genocide. This is looking at the evidence, making an evaluation of risks versus benefits, regulating the medical profession the way the state's been doing for hundreds of years.
Of course.
And I think, though, it is important that we remember that there are people involved in this. We don't want to be callous about it. We don't want to be snarky about it. But we need to make sure that our institutions aren't co-opted for ideological purposes when the medical data doesn't support that.
It's interesting. Abigail Schreier, a Wall Street Journal reporter for many years, wrote a book called Irreversible Damage, The Transgender Craze Seducing Our Daughters. She wrote the book about 10 years ago. But even then, there was an explosive influx of these prepubertal and pubescent girls, roughly ages 12 to about 16 or 17, that were just taking off in skyrocketing numbers. In fact, some estimates have in the past 5 years a 4,000% increase in trans-identified girls under the age of 18. I know you're a dad of 4. I am a mom of 3. I'm going to tell you what, teenage years are tough. I don't think anybody sails through that without some hormonal involvement where kids go, oh, nobody likes me and I have to do what everybody else is doing. And I see these people doing it on social media and my favorite celebrity is talking about it. and isn't influenced by that. Because these are, listen, the prefrontal cortex is not developed till the age of 25. I mean, I think at a certain point we have to say, we just want kids to be kids. And this is part of the reason I think we're both so passionate about the issue. And part of it is that it's hard to identify sort of what the ignition was. And that's one of the questions I was going to ask you was, how did we get to this cultural moment? It's easy for me to identify, well, if we're talking about government involvement, it was President Biden's executive order in January of 2021, where he very glibly instructed all the agency heads to reinterpret sex to include gender identity. Well, when you hear it coming from Washington, and it's trickling down through every one of the federal agencies, that is impacting all the federal recipients at the ground level, your schools, your hospitals, your charities, and you suddenly go, well, if this is the directive I'm getting, if my funding's on the line, it makes it that much easier, I think, to swallow that bitter pill for people who are at the ground level.
Yeah, and I would note in passing that Tennessee was able to get injunctions against many of those federal regulations.
Oh, I know it.
Because they are just not aligned with the law. But, it's not just a matter of the federal government, but that's a big part of it. One of the arguments that just I could not take seriously is the idea that we're talking about a politically powerless group.
Yeah.
Because we had amicus briefs from a bunch of the medical organizations, from the American Bar Association. We had Hollywood celebrities weighing in.
Yeah.
The American elite has, to a very large degree, bought into the ideological underpinnings here and is fully supportive of reinterpreting our laws in ways that the laws just weren't intended to cover. Our laws against sex discrimination were not passed by people who anticipated them being used as laws against gender identity discrimination.
Yeah.
Our Constitution was not passed by people who, I think it's fair to say, intended for it to be used to require the government to let kids have these irreversible medical procedures done to them. The elite has moved in a direction very different than where the law was in a very short amount of time. I don't fully understand what happened, but if you look at the numbers, I don't fully understand why the number of kids doing this has gone up so radically either. And the fact that it has increased so much and we don't understand why is a huge cautionary red flag.
Yeah.
Again, there will always be people with gender dysphoria. It's a condition that's been around forever. And it's a hard thing to live with. But the fact that there are suddenly so many more people claiming this is reason for real concern about what the drivers are.
Yeah. And I think the problem is that for a lot of these parents, they don't have nefarious purposes in mind. They don't want to go out and make a mistake with their children. But I think that in a lot of these cases, these parents, in wanting to do the best thing for their children and buying the prevailing cultural narrative. Of course, we know the numbers don't support the cultural narrative because the numbers actually say 72% of Americans want restrictions on gender-affirming care for minors. 63% of them want it criminalized. And this is brand new. This is out from Neapolitan Institute, formerly Rasmussen Report. So we have very, very recent data indicating that 3/4 of the country is saying, whoa, this has gone way too far. We seem to be, at least the people in positions of power, willfully ignorant of the scientific disparities. That came to my mind, I think, a little bit yesterday. You mentioned the interaction with Chase Strangio, who's the attorney for ACLU, biological woman, identifies as a man. It was interesting because we were talking about suicide, and that is, I think, one of the most important prevailing defenses against attacks on laws like Tennessee's SB 1. It will not increase suicide to allow these kids to wait. And if anything, the Cass report, which got a ton of airtime yesterday, which is the 9-year longitudinal study, 10,000 kids out of the National Health Service in England. The doctor is not a hack. She was the former president of the Royal College of Pediatricians, was tasked with taking a look at the expansive data on the impact of these interventions. Her finding was the science is shaky at best. If that isn't a sounding alarm to those of us in America, is it that we lack enough supportive science, or we're just ignoring the science like that of the Cass report that already exists?
Well, you see medical groups like Do No Harm that are just losing their minds over the fact that evidence-based medicine has been thrown out the window in this area. And part of it is some very, very effective advocates, ideological advocates who have co-opted the major medical organizations. If you read the Alabama amicus brief in the case, it talks through how WPATH's guidelines were written not just by doctors, but by social justice lawyers, by Biden administration activists, by people who aren't looking at the medical outcome, but they're looking at achieving the political and legal outcomes that they want. And when you start politicizing science like that, rather than maintaining a neutral perspective open to falsification, you're going to get bad science. And it's incredible how quickly this has happened. Maybe the groundwork was laid for years, but all of a sudden there was a very hard activist group driving the bus for American medicine generally. And only a few people really seem to have noticed. A lot of the research to the contrary has been suppressed. Either it's been de-amplified or it's been held back from publication. The NIH study is getting a lot of interest. I think we filed a FOIA request on that recently in Tennessee. But you just see all the contravening evidence shut down. And so Europe here is absolutely critical as a heuristic for understanding what's going on. Because if it was just Tennessee and Texas and the other red states against the blue states and the entire American medical establishment and the ABA and Hollywood and all these institutions and the White House just totally bought in, it would be one thing. But when you have these progressive countries that were previously so enamored with this treatment who are now saying the research doesn't bear it out, we need to severely restrict access, that lets us calibrate against reality. It's not just an ideological thing. It's not the troglodytes in the red states being stupid. It is the co-opting of the imprimatur of the American medical establishment by a consensus, an artificially created consensus at the expense of the evidence. Consensus-based medicine is bad. We've seen it happen before. These things come up every few decades where there is a medical trend that is ultimately proved to be morally wrong. We saw it with lobotomies. We saw it with eugenics, where the medical establishment, the legal establishment were bought in. And after the fact, people looked back with an immense amount of regret.
In fact, it's so funny. I often called this sort of zeitgeist in, quote, gender affirming care for minors, our generation's Tuskegee experiment. I think we're going to look back 20, 30 years from now and think to ourselves, what did we do? We sterilized an entire generation of kids who have no concept at 13 if they want to go on to father children or nurse a baby. These are lifelong decisions. We restrict the conduct of minors in every context, from being able to sign contracts, to register for the draft, to get a tattoo, buy alcohol, or smoke a cigarette. And yet here, ostensibly, they have the wherewithal through their parents to be able to say, I think I want to take chemical castration agents. That to me doesn't pass the smell test. And the Cass report, which I mentioned, was distinctly and repeatedly mentioned by Justice Alito. We were talking a little bit about his dialogue with Chase Strangio. earlier. And one of the things that he asked him was specifically about this question of suicide. And Chase sort of equivocated a little, and then he opened up the report and said, on page 195 of the Cass report, it says there's no increase in suicide. 10,000 patients, 9 years, no increase in suicide. And Chase had to say, yes, there's no risk in suicide, but there's a risk in increase in suicidal ideations. Okay, even if you accept that as true, once again, I go back to the issue of hormones are crazy things. You got kids during puberty. Not a one of them gets out unscathed. Not a one of them doesn't have a pimple or go through a breakup or, wake up with hair in funny places. These are issues that we have to let the kids get through. We're creating a class of victims is what we are. I think Generation X, which is my generation, we look back now on Generation Z, many of whom are now our kids coming up through the ranks, and we're going, oh man, we had it tough. We were the kids who were thrown out, like drink from the water hose in the garden hose and come back with a street light come on and don't call me. I'm going to drink a tab on the front porch and sit with my friends. We were all pretty free range in the 70s. And then you get these kids and we're willing to medicate. And I mean, not only medicate, create lifelong patients, amputate for psychological conditions. I don't think we have a gender or a transgender rights crisis in the country. We have a mental health crisis in the country. That's the big issue I think no one is talking about.
Well, we actually sued one of the social media platforms because of the mental health crisis. If you look at the numbers, they are astonishing. The radical increase over the last 15 years in depression, anxiety,
yes,
suicidality, sleep deprivation, all these indicators of poor mental health has been a plague on this generation. And they really are dealing with a mental health crisis. And, I don't know what the research will ultimately show with respect to any connection between that and the explosion in kids seeking treatment. Again, I want to reiterate because it comes up often. There are always going to be people with gender dysphoria. It is a real condition. But the number of people who appear to be thrown into that bucket who maybe don't belong there seems to be on the rise.
Yeah, I would agree with that. So one more question on the case and then just some fun personal questions. Nothing too pressing. So I want to go back to that issue of immutability because we mentioned a case called Geduldig. We mentioned, we heard terms like immutability. And remember, this is if you don't buy sex discrimination, then how about transgender status discrimination? And that means you got to treat it as a suspect class and you have to close your eyes to the fact that the traits are not immutable. And Justice Alito, once again, who I think was absolutely on fire yesterday, went to Chase Strangio and said, okay, are you arguing that transgender status is a suspect class? Yes, I think it would satisfy the test of immutability. Now, remember, cases like Frontiero versus Richardson, the court says these are accident of birth, right? Sex, race, national origin. You can't do anything about these characteristics. You're born with them. They're deserving of special protection under the Constitution. And so he said, okay, well, what about an individual who's gender fluid? Or what about an individual who changes genders down the road? And it was very clear Chase was struggling. And he said, so it's not immutable, is it? And I think that right there was the death knell for we're going to create a new suspect class argument. I don't know if you heard it the same way I did, but I thought if they find anything, they're going to go for sex discrimination, but the transgender status discrimination, I don't think is going to fly.
It was a tough moment for their side.
Yeah.
Now, I think they had a pretty long shot argument to begin with, just based on the court's practices over the last decades in terms of creating a new suspect class. But there are a couple of reasons. The political power argument, as I said, seems crazy when the president of the United States and all of the major elite institutions are on your side.
Yeah.
The immutability argument is very difficult. Part of the problem is transgender is such a broad umbrella term, and I think in an indication of the way that things have gotten particularly weird in the last few years, now it's not just a matter of people identifying as the other sex, which is traditionally what we thought of. I mean, WPATH recognized eunuch as a gender.
Yeah.
You've got gender fluidity. Now, I guess the counter argument is, well, yeah, their gender changes, but their gender fluidity is immutable. They're always going to be gender fluid.
Right.
But that seems like a pretty tough sell to the court.
Yeah.
And it's an umbrella term that embraces some pretty out there concepts in addition to what's traditionally been viewed as the transgender orientation, identity.
Yeah.
And the broader the term gets, the harder it is to take it seriously as a legally suspect class because it encompasses so much.
Yeah. All right. So you've got 4 kids. What did they think about the fact that their dad made an appearance at the Supreme Court?
The younger ones were really unhappy that I was going to be out of town for a few days. The older ones understand that it's a big deal, but don't know that much about what's going on. They think it's pretty neat. I've been getting this really encouraging outpouring of support in Tennessee. And so they'll have random strangers come up and tell me they're praying for me.
Oh, nice.
And I guess they're just taking it in stride. I mean, they probably think that happens regularly. Man, be great if it did happen regularly to everybody. But they're rolling with it.
Yeah. All right. So what is next for the Attorney General? You have been doing such amazing work, not just in this case, but I mean, you've sought to not only protect kids from these online platforms, but protect your citizens from forever chemicals. And you filed a brief in support of West Virginia's women's sports law. You guys have been very active in defending the notion of women's equality in education. Where do you go from here?
So There are some strategic decisions being made that are still in the works. One of the key things is figuring out what's going to happen with all of the regulatory litigation through the transition. There is a lot going on, and it's going to take some work to figure out exactly how to dispose of everything. Some of the cases may continue. And then there are many threats of new regulatory litigation against the Trump administration. And we're going to have to take a look at that. And there may be some amicus brief work coming up on that front. There are some significant antitrust cases that we're involved in right now. Google is obviously a big one. We're at the remedies phase there. DOJ's got a transition coming up. But there are some other really neat cases. There are a couple algorithmic cases where AI is being used essentially to skirt the antitrust laws. So, if you had a bunch of people in a room with a whiteboard just writing out all this data, it'd be a slam dunk case for the DOJ.
Right.
But when you put it into the black box of the algorithm or the AI, you can achieve exactly the same results in a way that's a little bit harder for the regulators to stop. And, there's a lot of foundational work to be done as technology progresses and making sure that we're guaranteeing the kind of competitive market that we need. I'm not for radical antitrust enforcement, but I think we've seen a lot of consolidation, and there are new ways of sharing information that are potentially threats to the functioning of the market. So we're looking at that. We're looking at ESG issues. It seems like we're on the side with momentum right now on that. A bunch of states just filed suit in an antitrust case against BlackRock and some of the other asset managers. We had sued BlackRock a year ago. We're still involved in that litigation, and so have not engaged in the new suit. But there are a lot of other potential suits out there involving various entities associated with the management of people's pension funds and other institutional investments, where the fiduciary duty to maximize return on investment has been turned into an opportunity to use that financial leverage to inflict policy goals on industry in ways that fundamentally undermine our constitutional system. So we're looking at that, and we'll continue looking at that, and hopefully we'll be able to return the country to a place where if you invest your retirement expecting a maximum return, you're going to get the maximum return. It's America. So if you choose to invest in a way that achieves these policy outcomes, you're allowed to.
Yeah.
But people can't play games with other people's money. And then we've got the forever chemical litigation. Tennessee is a very business-friendly state, and we want to keep it that way. But there is a role for government in protecting citizens when things go off the rails. We don't want to bankrupt companies. We want to solve problems. And if companies are willing to come in and work with us to ensure that the damage done to the people of Tennessee is fixed, that's great.
Yeah.
We will litigate hard when we need to. But if there's a way to achieve a constructive solution that takes care of our people, I'm always partial to going that route. And then who knows what else is going to come up. I have an incredible team. I've been blessed with so many great attorneys, and they are very entrepreneurial. And I expect we will see exciting new developments in areas that I'm not even dreaming of right now. We'll see.
And at some point, are you going to take a nap?
I didn't take this job to get bored. I could make a lot more money doing something different and probably work a little less doing that. But when you love what you do, when you're serving a cause bigger than yourself, when you're helping people, it's not always easy to decide what to do. You want to do the right thing. Sometimes it's not clear what that is. But it's a whole lot better to be in a position where that's your challenge, where you at least care about your work. So, I'm only going to be AG for so long. I don't know how long that is, but there is a finite limit to that. And as long as I'm in the job, I'm going to do everything I can to do it as well as I can do it.
Well, that's encouraging for those of us out in D.C. who watch what states like Tennessee does and understand exactly how well you are protecting the people who are under your care. General Skrmetti, it has been an absolute pleasure to talk to you. And I don't want to make the other guests feel bad, but it's been my best interview so far. So we'll be right back on Case in Point. Well, that's it for this week's episode of Case in Point. Thanks so much for joining us and for listening in on a conversation with a brave attorney general from a state that is doing everything it can to prevent minors from being chemically castrated and harmed by the notion of transgender medicine. We will probably hear the outcome in this case, United States versus Skrmetti, at the end of the term. That's usually when they release the biggest blockbusters of all of the cases on their docket. So expect an answer to what the justices believe about this sometime toward the end of June 2025. In the meantime, follow us on all of your favorite podcast platforms and be sure to share this podcast with some friends of yours that might need a little law in their life. Follow us on X at Case in Point Pod. And until then, friends, court is adjourned.